First case is CHRYSSAIDIS, I hope I pronounced that correctly, CHRYSSAIDIS, versus State Farm Mutual. Do you wish to reserve any time?
Yes, I'd like to reserve about 7 minutes.
All right, sir, you may begin.
Thank you. May it please the Court, I'm Jeff Dobson, I represent Mr. CHRYSSAIDIS. As the Court is aware, this deals with the question of summary judgment that was entered in an action brought by Mr. CHRYSSAIDIS, the State Farm Mutual Insurance Company, and Copart Salvage Auto, relating to the sale of a Honda automobile. The vehicle had been certified to the state of Florida as being unrebuildable, and the effect of that is that the vehicle can never be registered within the state of Florida. The vehicle was sold by Copart on behalf of State Farm Mutual Automobile Insurance Company to a Laurel Auto Sales in the state of Kentucky. There was evidence which was found. There was an interesting thing in the case, which is that originally there were motions to dismiss which were denied by the judge to whom the case was assigned. Then there was a motion for summary judgment which was denied. Then there was a restated or motion for reconsideration on the motion for summary judgment, which was again denied by Judge Traynor.
Counsel, correct me if I'm wrong, but weren't there additional items that were put into the record before the senior judge made his ruling?
The only thing that was additional that was added was an affidavit by someone from the Department of Motor Vehicles, which was rendered an opinion that the sale of the vehicle was not illegal.
Why isn't that new evidence that then would allow the successor judge to once again make a decision based on the merits, especially in light of the fact that you can file successive motions for summary judgment?
The Judge Traynor, had determined that Copart knew that the vehicle was to be sold for the purpose of retail sales rather than for destruction.
Yeah, no, but the issue is you're complaining that the second judge could not overrule what the first judge had originally decided, and generally, if you know, in light of the fact you can file successive motions for summary judgment, if there's new evidence presented, such as an affidavit from another witness that wasn't presented before, you can file another motion and have it reconsidered.
If there was and let me make it clear that that is only a sub-bar on the question of the primary issue, which has to do with whether or not the sale of a vehicle under those circumstances by someone who knows that it is to be sold, put into the stream of commerce in violation in the stream of commerce, knowing that it cannot ever be registered in the state of Florida.
Counsel, let me ask you this question. Would you be willing to concede that if the same judge had stayed on this case, that when the renewed motion for summary judgment came up, he could have changed his mind and ruled?
Oh, he could have. I doubt that he would have, but that's...
well, but I mean, he had the authority.
In our initial brief, I thought I made it that we recognize the law to be that while...
Well, but you made the issue one of authority, and my question really just goes to whether or not he would have authority to change his mind and enter a summary judgment. Whether it's right or wrong, I'm not getting into that. And then why shouldn't a substitute senior judge have that same prerogative?
What is the Florida case law in that instance? It indicates that when a substitute judge comes in, that he should be very loath.
Very what? I'm sorry.
He should be very loath to overrule determinations that have already been made by...
That's not the same thing as a prohibition against it.
No,
it's just saying you ought to do it very reluctantly, and can't we assume that the judge in this case did it reluctantly?
I don't know that he did it reluctantly. It was not a fast.
Well, you know, all of the aforementioned notwithstanding, if he was right on the merits, then it doesn't make any difference, right? Because
That-
you haven't been harmed, and we only reverse when an error is a harmful error.
That's correct.
Okay.
And I thought I had made that point in our initial brief, that it was not as a matter of lack of authority, but when it went to the issue of when summary judgments are entered, they should be entered if there is doubt as to whether summary judgment should be entered.
Okay, so why don't we just bypass that issue as to the authority of the successor judge and just move right into the main issue here?
The main issue has to do with, and we cited in our reply brief, a case out of Alabama, which indicates that a vehicle should be sold and titled as if it were to be sold in that state. And in this,
Counsel, would you concede that at the time that this happened, when State Farm got the certificate, they were complying with the law as it existed at that time?
no, sir,
You wouldn't?
I would not.
Now, tell me why you wouldn't.
I would not, first of all, when you read the statute, if you were to read it as Copart and State Farm read it, then the whole statute, in reality, becomes meaningless relating to certificates of destruction. What it really says is, okay, you can sell the vehicle outside the state of Florida and forget whatever else is contained in the statute. That is the basic position, is that they can legally sell it outside the state of Florida. Well, they have put into the stream of commerce a vehicle which has a defective title. It can never be registered in the state of Florida. It is not a good title to anybody who comes along afterwards for that reason, because a title to automobiles, like any object, consists of a bundle of rights, which is the right to freely transfer the vehicle. That vehicle cannot be freely transferred.
What specifically were they supposed to do under the law that existed at that time that they did not do?
It should have been transferred with a certificate of destruction, meaning that it was be sold to someone who was going to.
It says, maybe I'm reading the wrong statute, but it looks to me like it says a salvage certificate of title or certificate of destruction.
That's correct.
Well, so what
In
does
a
the
particular
word
instance,
"or" mean?
The certificate of title had been surrendered to the Department of Motor Vehicles, who
That's what the
issued.
statute
They
says.
actually transferred it by means
But
of
wasn't
bill
it
of sale.
wasn't it a salvage certificate of title or not? I mean, did it comply?
There's a difference between a salvage title and I think a certificate of destruction. To begin
Well, okay, but what does the word "or" mean then?
with. That, I don't know, but I would
Don't know
point
what
out
that means?
that this court has also indicated that changes in statute.
Why wouldn't that mean a salvage certificate of title or certificate of destruction? Either one would be sufficient to comply with the statute.
In this
Wouldn't that be a
particular-
reasonable reading of the word "or"?
That may be a reasonable reading.
Thank
The
you.
question here is, however, that what the evidence in the record indicates, that they transferred it by a bill of sale, not by, they issued a bill of sale.
What exactly is a salvage certificate of title then?
I don't know what it is,
You don't know what that is?
except that, the statute makes it rather clear.
But you're saying they didn't even comply with the requirement that they issue a salvage certificate of title?
They were supposed to, they surrendered the original title. Any subsequent titles should be
What did they say
transferred not
on
as
the-
a salvage title,
what-
but as an unrebuildable vehicle.
What did they say on the certificate of title when they surrendered it? Did they put any notation on it?
The vehicle, title was surrendered to the Department of Motor Vehicles. And now what happens is they're in the record, they're contending that they put on there a disclaimer of the vehicle was not warranted, among other things.
So you're saying they didn't give a salvage certificate of title either?
They indicated that later on it was indicated as being flood damaged rather than one that was suitable only for recycling.
Well, would that qualify as a salvage certificate of title or not?
I don't know. But I think that one of the other points that make
Was there a salvage certificate of title issued for the vehicle by the state of Florida before it was sold to the
I'm
sold by
not
Copart?
clear on when any certificate of titles were issued by Tallahassee. We, in the initial complaint, had gotten all the records we got from Tallahassee. which indicated that the title had been surrendered. Later on the affidavit, there was the indication that there is some indications in the record there may have been a, quote, salvage title issue.
Counsel, you would agree, though, I think, that if the car had stayed in Florida and was sold in Florida and they applied for a certificate of title in Florida, they wouldn't have gotten it.
They wouldn't have gotten any title. It cannot be.
But instead of that, they go to Tennessee. So doesn't Tennessee law then control who gets a certificate of title and under what circumstances?
That's the significance of the Alabama case that we cited, which indicated that that was a lemon law case in which the Chrysler Corporation, that the vehicles could be registered in the state of Alabama only if the title had been branded. And they got an opinion from the Attorney General of the state of Alabama that they could sell it outside the state and would not have to brand the title. The vehicle comes back to Alabama, it can't be registered. And the Alabama court held that it always has to be sold as if it were being sold in the state of Alabama.
But that case doesn't involve a situation where the car is sold to somebody in Tennessee and they get it registered in Tennessee pursuant to Tennessee law, which doesn't have all these requirements that Florida law has.
In the particular instance, it was sold outside the state of Alabama and ultimately came back to Alabama. And that's the same thing we have here. It was sold in Tennessee, went in North Carolina, and then came back to Florida.
Well, except for the fact that in our case, Tennessee issued a certificate of title or some evidence of ownership, whether you call it a certificate of title or not in Tennessee, I'm not sure, but they issued something that allowed this individual to legally drive the car in Tennessee. Then it goes to North Carolina, and North Carolina issues a certificate of title.
Absolutely clean title in North Carolina.
Yeah.
Oh, I'm sorry, could you have another question?
And then it comes back to Florida, and it can't be registered.
Is there any indication that the certificate of title that was issued in North Carolina was illegal or contrary to North Carolina law?
Yes, there was. The indication is that according to the information provided by Copart a year after the vehicle was sold, North Carolina apparently wanted to re-register the vehicle as having flood damage.
Let me get back.
After they had issued the clean title.
Let me get
So
back to
apparently it was a violation of North
Let me get
Carolina.
back to the 1997 statute, which doesn't have the certificate of destruction requirement in it. I think the 2000 statute does. The 97 statute doesn't. And it just simply requires that within 72 hours that the insurance company shall forward the title to the department for processing. And then it says that the owner insurance company may not dispose of the vehicle that is a total loss before it has obtained a salvage certificate of title.
That's correct.
All right, so you said they turned the title in to the...
Yes, they did.
Okay, and then what happened after that?
The vehicle went up to North Carolina. It was...
Or was a salvage certificate of title issued from the department or not?
I don't know when it was issued. It was originally...
Was it or
sold
not
by-
ever issued?
It was originally sold... Thank you. It was originally sold by means of a...
No, hold on now. They, I think, indicated they turned the title in to the department, and then the department is supposed to issue a salvage certificate in the event that the car is going to be sold. Did the department ever issue a salvage certificate of title?
There is some indication that at some point they may have,
If they did that, then they complied with the 97 statute, right?
except if they put in, it still is not a good title that is issued to subsequent buyers, because it's a vehicle that cannot be driven
Yeah,
legally.
but I know, but they complied with the 97 statute if they did that.
There are
Supposed
two
to be.
things which come into play on any vehicle, which is you have to convey a good title. And a title, which is a salvage title, is not a good title in the sense that the vehicle cannot be registered.
Yeah, but if the statute says that that's what the insurance company is supposed to do, turn the title in, and the department issues a salvage certificate of title, and they did that, how are they liable?
They're liable because they knew that it was being sold for purposes of violation of the law.
Where is that in the 97 statute that says that, you know, once you you complied with that requirement, and then you still sell it thinking it's going to be in the stream of commerce, that you're liable anyway? Where is that in the statute?
What it's really saying is you shall not aid someone else in violating the law. And it does talk about aid in the statute. And in that particular instance, they're aiding Laurel Auto Sales in violating the law.
Thank you, Counsel.
Thank you.
Well, I had one more question. Counsel, I had a question I wanted to get answered before we sat down. You keep saying that it's not clear when this salvage title was issued. I'm looking at a document that purports to be a document that was in the record here that is a certificate of title, and it says date of issue August 5th, 1997. Is that a document from the record in this case?
That should be a document in the record.
Okay, and it says salvage title, salvage title, salvage title,
That's in the record.
And the date of issue is contained in the face of the document, right?
Yes.
Oh, okay, all right. Okay, that's all I have. Thanks.
May it please the Court, Steve Faustini on behalf of Copart Salvage Auto Auctions, Inc. Your Honors, as you've been talking about, the crucial aspect of this case is the statute 319.30 sub 3 sub B that we've had discussions about. And as it's been indicated, in 1997, when this transaction took place, there was only one way that an insurer could dispose of a vehicle under the statute at that time, and that was to submit it to the state, obtain the salvage unrebuildable title, which was issued prior to this vehicle being auctioned, and then put it up for auction. Copart handled this transaction for State Farm and complied in every aspect with the wording of the statute at the time for disposing of such a vehicle. The vehicle was transferred to the successful bidder at the auction, both with the title, the salvage title, and with the bill of sale. It was sold to or auctioned to a company in Kentucky that took the vehicle there, had the information obviously fully disclosed about the condition of the vehicle, did repairs on the vehicle, submitted the vehicle for inspection to the state of Kentucky, and Kentucky issued a title that carried a water damage brand on the vehicle. The vehicle was sold to a third party, a resident of North Carolina, who then drove the vehicle for 3 years, 48,000 miles, before she in turn sold it to Mr. CHRYSSAIDIS. Now, when she had possession of the vehicle and registered or titled it in North Carolina, for some unknown reason, North Carolina did not put the water damage brand on the title. As Mr. Dobson indicated, later, about a year after that title, after the vehicle was sold to Mr. CHRYSSAIDIS, North Carolina did try to contact him to tell him that it would have to be retitled with that water damage brand. Part of the appellant's argument is that there is a violation of the statute because East Laurel was going to rebuild the vehicle and that Copart and State Farm should have known about that. But what statute does that violate? Again, every aspect of the statute was followed by Copart and State Farm in handling this vehicle. It was auctioned to the highest bidder. Copart has not had any contact whatsoever with the appellant in this matter from the very start. Again, the appellant doesn't take possession of the vehicle until 3 years after it's auctioned. Obviously, there's no violation of Kentucky statute, and that's not the main case here. It's another jurisdiction. What Kentucky did is evident from the record. There's also argument from the appellant that Copart should be liable here because East Laurel, who they auctioned it to, intended to engage in fraud. Again, where's the fraud? There's no allegations in the complaint or pleadings to substantiate it. East Laurel did its repairs. It then got the title that was water damaged, had the water damage brand on it, and sold that with full disclosure to this customer because it was on her title. The issue of fraud, as you know, there's 4 elements you have to show with that. The misrepresentation, making the misrepresentation with the purpose of knowing somebody's going to rely on it, the actual reliance, and damages. With regard to those first 3 elements, there's no allegations at all in the complaint substantiated. Therefore, fraud can't stand in this action against any of the defendants, because regardless of who appellants try to say committed fraud, again, those elements are lacking. There were 3 counts that were pled against defendant Copart in this matter. One fraud, one under the Florida Deceptive and Unfair Trade Practices Act. As was pointed out in the motions below, there's an exclusion in the Florida Deceptive and Unfair Trade Practices Act for motor vehicle auctions, because the section of that act that deals with vehicles talks about things that dealers are prohibited from doing. But there's a specific exclusion for motor vehicle auctions. Copart is a motor vehicle auction. Therefore, position of Copart, it is not liable under that statutory provision. The last count was for civil theft. And without showing the grounds for fraud or anything under the Florida Deceptive and Unfair Trade Practices Act, there's no grounds for civil theft, and even beyond that, there's no allegation there was any felonious intent on the part of Copart in any part of this transaction. And because that's a necessary element of the civil theft, that count can't stand as well. With regard to all 3 counts of appellant's complaint regarding Copart, there's no genuine issue of material fact, and Copart contends it is entitled to summary judgment and asks that it be affirmed in all respects.
Thank you, counsel.
May it please the Court, my name is Rhonda Vargas, and I represent the other appellee in this matter, State Farm Mutual. The question was asked of the appellant, what was State Farm and Copart supposed to do? That's the crux of this case. State Farm completely and fully complied with the 1997 statute. There was an affidavit from Gail Andrews which brought forth the application to the state of Florida for a salvage certificate of title. The application indicated that this car would be unrebuildable. It was an affidavit submitted by State Farm to the state under the law. The affidavit of Andrews also provides a copy of the salvage unrebuildable title, which was in fact issued, and according to the undisputed facts in the record, was given to East Laurel at the sale. State Farm had no choice but to have a salvage unrebuildable title. The date of that title was approximately 20 days prior to the sale. So it's sold at an auction sale as an unrebuildable salvage vehicle as required by the statute. Absolutely no requirement that it be transferred by a certificate of destruction at that time. In fact, the certificate of destruction provisions of the statute were really for different reasons. Say for when, for example, a tow truck company has a vehicle that they've towed away, and they've given proper notice to the owner and the lessor, and they want to destroy it, so they get a certificate of destruction for permission. That's not what the issue was here. The law was that that car was to be transferred by a salvage unrebuildable title. It was. The purchaser had the salvage unrebuildable title, also received a bill of sale saying, by the way, this is water damaged, and we're not giving any guarantees. And there have been a number of questions about where the salvage unrebuildable title was located. I think it's at both 117 and 252.
Your argument is basically the same as his, isn't it?
It basically is that State Farm, who basically sold this in full compliance, there was nothing else they could do. And in fact, they were successful. The purpose of that statute is so that this car cannot get a certificate of title and be...
We understand.
Okay.
Okay.
And the other argument, so that's our primary argument. They did everything they did, and in fact, Kentucky knew with the title. The only thing that happened was a clerk in North Carolina forgot to put water damage on it. He can't drive it in Florida. That's what the legislature intended. Now, the complaint in this matter basically alleged that the deceptive trade practice was not to correct this title. The title's accurate. The title is required by law. The fraud was to not to disclose it was an unrebuildable title. That's what the complaint alleged. The certificate of title.
You might learn to take a hint when you're ahead.
Okay.
I was trying to give you, I mean, if you want to keep going, that's fine.
No, that's fine, Your Honor. I just...
Yeah, I don't want to deprive you of your oral argument at all.
Okay.
Yeah, you want to keep going, forward your head.
Well, in that note, then I will conclude. State Farm believes that the summary judgment was required under the law, and they have absolutely no liability in this matter, and request that you affirm it.
Okay.
Thank you.
Thank you, counsel.
Isn't the proper party in this case the person that your client bought the car from, or someone else, you know, higher up in the chain of title? Isn't that who you should be suing here?
That's an argument that the co-part of State Farm made, that we should.
Why isn't that a very good argument?
It's a practical one. You know,
Yeah, it seems to me to be very...
$14,000, you know, or whatever you go.
I mean, ordinarily, you're not in privity with the defendants. Ordinarily, under any common law theory, you'd have to have, you know, privity. Absent products liability, you'd have to have privity for fraud or, you know, these types of things. So, you know, without the statute, basically, you really haven't got a claim against the defendant.
It's possible there may be a claim. There were two cases we cited. One was a Montana case, which had to do with a defective title, where the title had been questioned in the state of Wyoming, and the other was the Alabama case, both of which indicated that the privity requirement was not required because the duty is owed.
I think your problem here is I don't even think you have the statute to help you. I mean, I'm just being frank with you and telling you. I mean, I just don't see that you've got any relief on this statute either.
Thank you.
Okay, thank you.
Thank you, Counsel.
Okay.